Good afternoon, everyone. It's Allison Schaberg here, Consolidated Planning Group. I am happy to be with you here today. We are sponsored by Deborah Irwin with Workforce Solutions, the Student Hireability Navigator. Perhaps you've worked with her in the past. If not, she might be a good contact for you to reach out to. She couldn't be with us today. She had another commitment that she had to take care of. So today, we cannot see you and we cannot hear you, but we know you're there and we're glad you're here. We do want to take as many questions as we can as we're going through this presentation today. Consolidated Planning Group is a holistic special needs financial planning firm. I share with you in that I'm a parent and a professional in working with special needs, and we put out a lot of webinars on a pretty regular basis as it relates to special needs planning and some considerations that families need to keep in mind as they have children that might be transitioning into adulthood, kind of any step along the way. So we do have a YouTube channel. We'll have that at the end of our presentation. And on our YouTube channel lives all of our past presentations, the different speakers, the different topics. And there is a variety of topics that might be applicable to you personally in your unique situation. So I definitely invite you to go out there and check that out. Our passion behind these webinars is really whenever I was navigating these waters for my own kids, I found that the process was a little bit difficult. And there's a lot of things as parents that we just really, really need to know. And there doesn't seem to be one central place where it's all located. And there's a lot of changing tides as our children are going from age 17 to age 18 and things that we need to be aware of. So that's kind of the method behind the madness of all these webinars that we put out. So today what we're talking about is Medicaid waivers. We're going to talk a little bit about SSI eligibility and preserving benefits as well. Waivers is something that is, I kind of call it a buzzword. We hear all of the time about interest list in the state of Texas. Where are you on the waiting list? Are you on the waiting list? How do you get on the waiting list? These are things that come up all the time. So first and foremost, if we have anybody that is recently moved to the state of Texas from another state, these waivers that we're talking about are state specific, and your waivers that you may have been on or may have received in other states don't necessarily transfer to Texas. The truth is about the waivers in Texas is that there is a really, really long waiting list at this time. And I guess it's really anybody's guess on how long it is. Sometimes we hear 15 years, sometimes we hear 17. There was a few years back that the waiting list was actually frozen for a couple of years. But the long and the short of it is a long path to actually getting a waiver. So it is important that you get your child on the list for any waivers that they may be eligible for. And we would suggest putting them on the list for all of those waivers, because you never know, when you're going to come up on the list, and the eligibility is going to be determined at the time that you come up on the list, not at the time that you put yourself on the list. Okay, so getting started, we're going to talk a little bit about these Texas Medicaid home and community-based waivers. So the point of these waivers is to waive off the cost of some care and to keep your kids in the community and avoid residential placement is the point of a lot of these waivers. So some of the ones, we've got kind of the acronyms that they go by and the full names here. We've got the Community Living Assistance and Support Services. This is CLASS. We've got Deaf Blind with Multiple Disabilities, Home and Community-Based Services, which is going to be HCS. And we have Texas Home Living, Medically Dependent Children's Program, Mdcp. We have the STAR Plus waiver. We have the Youth Empowerment, also known as the YES waiver, and Community First Choice, which is also thrown out there as CFC. So as we're looking at some of these waivers and what are they looking for? So first off is CLASS. So this is going to give the home and community-based supports to children and adults with related conditions. There's over 200 related conditions like cerebral palsy, spina bifida, and the related condition must have occurred before the child was age 22, okay? So deaf, blind with multiple disabilities is just that. It's not deaf or blind. It has to be deaf and blind with multiple disabilities. And this gives services for children and adults who have all of the following. But they also have another disability. So this is a waiver specifically for them. Home and community-based services, HCS, this gives services and supports to children and adults with intellectual disability or a related condition who live with their families in their own homes or in a small group home with no more than 4 people. We've got Medically Dependent Children Program, Mdcp. Sometimes your kids may be on a Medicaid waiver, like a buy-in program. This gives services to children and adults who are 20 and younger who are medically fragile as an alternative to receiving services in a nursing facility. Again, the point of these waivers is to keep your loved one in the community, home and community-based services, and outside of a residential living facility. So we've got the STAR Plus HCBS waiver, and this is for adults that are over age 21 to keep them in their community and not in a nursing home facility. Texas Home Living is going to give services to children and adults with intellectual disability. And for the state of Texas, for most places, that IQ score is 70 or below. And this is for people that are going, again, to live in their own home or their family's home. The Youth Empowerment Services, this is the YES waiver, and I like to talk about this one because this is one of very few waivers in the state of Texas that there isn't necessarily a waiting list for. This is a wraparound program. It's a Medicaid program, and this is giving services to children under the age of 19 with serious mental, emotional, and behavioral difficulties. So a wraparound program, it doesn't go on and on and on indefinitely. It's usually a year. We've also seen this program extended to 2 years, and I've actually even seen it extended as far as 3 years. But think about all of the alphabet soup and diagnoses of mental health: ADHD, ODD, BPD, bipolar. Another example of kids that might be a fit for this are kids that have been in trouble with the law. And that doesn't mean that all of them have or anything like that. Maybe they have had, they've run away. Maybe they've been in trouble at school. But again, this is, all of those diagnoses that encompass the mental health, the mental health area. Now, what I will say on the Youth Empowerment Services, if your kids have, severe disabilities, maybe they're nonverbal, severe disabilities, that the mental health diagnoses are clearly secondary or tertiary to the underlying diagnosis. They may not be eligible for the YES waiver. But if your child has diagnoses that are predominantly mental health, emotional, and behavioral difficulties, then they may be a good fit for this. But again, with this waiver, there is not a long waiting list on this. So you can check with your local authority. We're going to talk about that in a minute on how you can find out if you can get on the list for this. Community First Choice. This is one of the newer ones. This is going to allow states to provide home and community-based attendance services and supports to Medicaid recipients with disabilities. A lot of these waivers also have attendance services where you'll get so many hours, per week, per month, for attendance services for your loved one. And depending on which waiver that you actually qualify for will depend on the number of hours that are eligible under the waiver and the total amount of like the value of the waiver. Like some are $40,000, some might be $26,000 a year that might go into that particular waiver. So waiver eligibility, we talked about this a second ago, but most waivers are really for all ages except for the Mdcp and STAR Plus. But there is some financial eligibility for all waivers except for the Texas home living. And that financial eligibility on that monthly income cannot be any more than $23.82, which is within 300% of the SSI limit right now for 2021 is $794 a month. The $794 a month is what the SSI amount is that they pay, and then $2,000 is the assets that a person has to be under in order to qualify for SSI. But most of these waivers do not look at parental income. So when it comes to, people tell us all the time, I don't think I qualify. I think we make too much. You have to maintain your Medicaid eligibility to be eligible for one of these waivers. So that is an important thing. All of these individuals must meet the functional eligibility criteria for the specific waiver. But again, the key thing is to getting them on the list, because they're not going to be determined eligible when they get on the list. It's when they come up to the top of the waiting list. So a lot of the eligibility for these waivers is an IQ of 70 or below, with multiple disabilities, but intellectual disabilities is a key trigger for these waivers. Excuse me, I have allergies today. But I think one of the biggest takeaways that you have to know here is that your child may have a disability and they may not have an intellectual disability. Maybe they're on the cusp, maybe their IQ is 75, maybe it's 80. But we don't know where that will go from there, and so there is variations in the level of IQ and measured later on. We also have seen drops in IQ. A specific example would be kids on the autism spectrum. Maybe more so in boys in the ages of 18 to 22. They have a higher prevalence for other mental health diagnoses, such as schizophrenia, other things like that can come along. So we've actually seen where there have been kids that were not intellectually disabled prior, but with other diagnoses that came along the way, than they were. So the good thing is in this particular family situation that their child was already on the waiting list. They didn't wait till age 21 or 22 to get them on the list and have that, that really long waiting period that we were talking about as far as, being eligible for services. Okay. So there's two funding paths for waivers. We've talked about the interest list or the wait list. It's a first come, first serve. It's statewide, and the wait. So, we could call it an average of 14 years, sometimes more, sometimes less. But the idea behind it is promoting independence. It's going to prevent and divert individuals from institutions, and it's going to help individuals that maybe are already in institutions move from institutions to home and community-based services. Okay, so when we're talking about the wait list, I talk to a lot of families all the time. The families that we serve have kids with disabilities. We serve the professionals that, in capacities and agencies that serve them. One of the things that I hear all the time is we're on all of the waiting list. We're on all of it. We call them, we're on all the list. And so the thing is there is a couple of different ways that you go about doing this. The interesting thing in Texas is there is no login where you log into some state website, you create a username and password, and you put yourself on the list, and then you can log in and periodically check and see where you are. I wish they would do that. I don't know why they haven't yet. But as it stands right now, you've got to go through your local intellectual disability authority. That's who you've got to go through to get yourself on the list. And so basically, Texas Home Living, HCS, Community First Choice, the YES waiver as well, you're going to call your local authority. So whether you call it a LIDA or a LIDA, your local authority. So with, being here with Workforce Solutions, North Central Texas, there's 16 counties in North Central Texas. So your local intellectual disability authority is by county, okay? So whatever county you're in, you have a local authority specific to your county. So you're going to want to call that county. if you have found yourself, like perhaps you got yourself on the list, maybe you lived in one county and then you moved to another county, you're going to want to call the local authority in the new county and get yourself transferred. You're not going to change your status on the list or anything like that, but you are going to want to update that local authority, letting them know that you've moved into to the county and get your case transferred from the other county to the new county. So when people say, I've got myself on all of the list, usually they think that they are really, really on every single list out there. And the reality of it is that they're on the HCS, Texas Home Living, Community First Choice, and maybe the Yes waiver. But there is a separate phone number for Mdcp, class, and the DBMD. And so that phone number I have on there. So if you don't know, a lot of times we've done this a long time ago, we don't know, and you could actually talk to your local authority and they'll say, yes, you're on all the lists, but you're on all the lists that they cover, not the Mdcp, class, or DBMD. Also for the Star Plus waiver, there's a separate phone number for that. So the big thing to know about this list is your local authority is supposed to reach out to you about every 2 years to just check in with you, ask if you still want to be on the list, verify that all of your information is still correct, your address, your phone number, your email address. If they can't find you when they try to reach out, they can take you off the list. Even though you didn't ask to be removed from the list, you can be removed from the list. So it is very, very important, even if you put yourself on the list many, many years ago, that you do update any information, contact information, emails, etc. So that way you don't get kicked off the list. If you haven't heard from anybody in a couple of years, I suggest reaching out to your local authority and just asking them where you are on each of those lists and get an update. So the website here, if you copy and paste that website, you put that in your browser. If you don't know who your local authority is, you can simply go to that website. You can put your zip code in, and it is going to tell you exactly who your local authority is for your zip code. So that is the biggest thing, is to double check on those things. Okay. So promoting independence, when we're talking about some of these waivers and we're talking about these long wait lists, there is something that is called a crisis diversion slot. These are slots that might be available to you much sooner than the wait list, but before you come up on the wait list. But this is a real crisis. Some examples of crisis that we've seen is families that have they have a loved one that has become aggressive or unmanageable. They are a threat to themselves or others. We've seen crisis diversion slots and examples where a caregiver has died, one or both of the caregivers has died, or maybe one of the caregivers has become ill themselves and are needing, treatment. And as a result of that illness, they are no longer to provide the caregiver services that they were once able to provide. But true crisis is what this is looking like. Now, for these crisis slots, again, you're going to want to call your local authority and they will help you with the process. Sometimes what we have seen is sometimes that you might get the wrong person when you call that local authority. They may not be as helpful in helping you navigate a crisis diversion slot. And there is another agency in Austin. It's called Every Child. Again, it's in Austin, and they also help, and they have people on the ground, boots on the ground in all areas across the state of Texas that can also help you navigate and get a crisis diversion slot if you're not making any headway with your local authority, and there truly is a crisis, there truly is a situation. Again, when we're looking at these crisis diversion slots and we're looking at them for kids that are, under the age 18, they're really going to stick to their guns on that IQ of 70 or below. So they're really going to look at that. So there are families that are truly in crisis and their child has multiple disabilities. They might be a threat to themselves or others, but their IQ is 80. And so then, this kind of this middle ground where there's not a lot of help out there. So then there is also the PASRR, Diversion and Transition from Nursing Facilities and Specialized Services. So these are just some things that you can keep in mind. Hopefully, you won't need a crisis diversion slot. Hopefully you don't have that type of crisis in your life. One more example of a crisis diversion slot. There was an example of a grandfather that we had that had custody of his adult grandson. Grandma had passed away. Grandpa was still working, is still working. Grandma had passed away. Grandma had been a caregiver, and the kid had become pretty aggressive and very, very difficult to deal with. But because of his care needs and the cost of his care needs, Grandpa still needed to work. But because of the issues that they were having with him, they really couldn't. They were really struggling to find any caregivers, and Grandpa was at risk of losing his job and his way to provide for his grandson. So that was another example of a crisis diversion slot. Okay. We have a question here. It says, what was the name of the agency that will help with a crisis diversion slot? So again, it's your local authority first, the local authority. And then again, you can find your local authority by going to that website in the slides. We will put an email out of today's recording with a PDF of today's slides, so you can have any links that are in there. But the other agency was called Every Child, and so Every Child, and they're out of Austin. But again, they have representatives all across the state. So that is, I would say start with your local authority, and if you happen to be getting nowhere, then you can really, you can reach out to Every Child. They're pretty helpful, and they really know what they're doing. I guess you could do it in any order. A lot of the local authorities are really trying, trying to help, and, sometimes they're understaffed. Sometimes your local authority has high turnover rate of staff, and sometimes that's problematic. And, if people are in training, they might not know of some of these things. So they're learning those things, but just know that this is something that is out there and it is possible and available. Okay. So we talk a lot about, special needs planning, consolidated planning group. We are a holistic special needs financial planning firm. And when we talk about, what are the differences, there's a lot of confusion on special needs planning and who we are and what we do, and who are the attorneys and what do they do, and how do we collide? How do we collab? How do we work together? So first things first, when it comes to special needs planning, your situation is specialized. So you do need to work with a specialist. If you have a child that might need care for the rest of their life, not just your life, you definitely need to take, kind of a disciplined approach to this planning. A special needs planner, we're really focused and nuanced on money in the right buckets. Is there enough money? Is there enough money for mom and dad to retire and be retired for 25 to 35 years? Is there enough money after that to fund a special needs trust for your loved one that may, live another 25 to 35 years after your death? So we're nationally certified as a Social Security advisor. We're nuanced in all things special needs, and I'm part of the Academy of Special Needs Planners. This is important to you because as you're planning for special needs, it's really important that we have money in the right buckets. And so while a typical financial advisor, they have a lot of similar licenses that we have, they just don't have the specialty in special needs and special needs planning. So that's kind of the difference on that side. And as it relates to attorneys, so we get calls all day long. I need guardianship, I need a special needs trust, et cetera, et cetera. So the special needs attorneys, estate planning attorneys that focus their practice in special needs, they're the legal documents, they're the paper, they're the guardianship, the special needs trust, the power of attorney, healthcare power of attorney, wills, et cetera. And basically, you need both of us. The attorneys don't do the financial side and the money in the buckets, and we don't do the legal documents, but we really do make referrals out for qualified attorneys. So just like we suggest that you're working with a special needs planner to help you, come up with the plan, the future care calculations that might need to happen, we also suggest that you don't work with a generalist attorney when it comes to your documents as well, because it is really, really a possibility that there could be mistakes in those documents. Your trust could fail to qualify for a trust in the eyes of Social Security. There's all kinds of things that can happen. And in that regard, we also, for all of the do-it-yourselfers out there, I understand, but when it comes to your legal documents, we do not suggest that you do any of your legal documents for special needs yourself. So getting started, you got to gather all of the necessary planning documents. What do those look like? Those documents are going to be your Social Security statements. If you're married, both of your Social Security statements, and we're going to get to that in a minute as to the reason why. This is everything that you have set up. This is your investment accounts. This is your insurance, maybe any coverage that you have both through your employer and outside policies that you have also purchased, maybe disability insurance, life insurance. This could be past employers, 401ks, 403bs, pension statements, any kind of bank statements, anything that's going to be potentially funding future care for your child or your own retirement. Those are the planning documents that are necessary. Also, if you already have legal documents in place, those will be things that you're going to want to gather as well. We suggest developing a letter of intent, and a letter of intent is something that we refer to as a family love letter. Oftentimes in a family, there's one family member that may be providing more of the caregiving services than the other. Maybe one works, one is a caregiver, etc. But the bottom line is what do other people know? So if you stepped out of this world today, or if you became incapacitated, do other people know what you know for the complex care needs of your child? And so this letter of intent, family love letter, whatever you want to call it, we do have a template for that. It's 20 pages long. It's form fillable. But what you're really putting in that letter of intent is everything about your child. We have forgot more about our kids than anybody will ever know. But if somebody was stepping into your shoes as a successor guardian of your child, they would pick this up and they would know what are their primary diagnoses, what are the medications, where were they born, what county, who are the doctors, what are the allergies, what are the religious preferences, histories of any surgeries, basically anything that makes your child tick, anything that makes your child melt down, all the good, bad, and indifferent go in this letter of intent. With the idea is that if a family member was picking this up, you could no longer talk, you could no longer, really convey your wishes, that they have a really good understanding of what your vision is as it relates to your child and the care for your child, both now and in the future. And as you're getting started with the planning process, we really want you to think about not only how you hope things will look for your special needs child in the future, but what about yourself, your life, your future, your retirement. We spend so many years working, and we have this vision of retirement that we're going to sail off into the sunset, and it's going to be wonderful. But that vision isn't as clear. It's blurry. It's foggy. If we have a child that's going to need care for the rest of our life, we don't have that luxury of sailing off into the sunset and being free and fancy free. But what does this look like? How do you find balance? Because what we know is a lot of parents put their kids' needs first, and they put their own needs, their own health needs, their own needs for respite and things like that on the back burner. But what happens is our own health will take a toll for that, and that's going to limit and shorten the time that you can be a caregiver for your child in the future. Let's see. I think we have a question. Okay. We have one that says, I know about RSDI. However, my retirement benefits come from TRS, not Social Security. Does my disabled child get any benefits through TRS? And that is a good question. And there are no benefits through TRS. Your child may be eligible to be covered under another parent's record. So mom or dad, it could be under either parent's record, but there is an offset. You're all right for Social Security purposes. There is an offset for state employees, for TRS employees that don't necessarily pay into the system. So it can be convoluted. So let's talk a little bit further about how we're going to fund care in the future. So first things first, when we start talking about preserving eligibility for state and federally funded programs, there's a lot of things that you got to know. But the bottom line, and we talked about a little bit ago, is SSI and eligibility for SSI. You have to have less than $2,000 assets in your name. So there are places that you can have money above $2,000, which is going to be in a special needs trust or an ABLE account that will not be counted against you for the means-based test for SSI. But basically, if you have money above $2,000, any other account than a special needs trust and an ABLE account, it is going to be counted against that individual for the means-based test. Excuse me. So for the means-based test, what we need to talk about here is prior to age 18 and then after age 18. So even though our kids are clearly disabled, some have very clear disabilities, others are not as clear. Prior to them turning 18, it's based off of your assets, okay? So this means-based test, even though your child is disabled, this means-based test is going to be based off of your assets, not the child. So if you're married, if you have more than $3,000 asset in your name, that number was 3,000 assets in your name. You can have one house and one car. But basically, if you have more than $3,000 assets to your name, then your child is not going to qualify for SSI and Medicaid. Once the child, and so that's if you're married. If you're a single parent, then that number is $2,000 assets to your name, and this is prior to them turning 18, so 17 and below. What happens at age 18 is when your child turns 18, it's based off of their assets, not yours. So even though they still live in your house, even though you might claim them on your taxes, it doesn't matter. It's based off of their assets, not yours. So if you're taking notes, it's important to not have more than $2,000 in your child's name when they turn 18. So what happens if you do already? What happens if you already have more than $2,000 in your assets in your child's name? The first things first, and this comes up all the time, is there's no such thing as hiding it from the Social Security Administration. You can't just hide money, right? But you can spend it down below the threshold and just keep proof of receipts. Our kids have a lot of care needs. You know, we've got out-of-pocket expenses for uncovered medical, prescriptions, therapy, private school. I mean, there's so many things that we are spending for these kids. So it's easy to spend it down and have proof of receipts for that. Another thing is above the $2,000 threshold, you can move the remaining amount over into an ABLE account or to a special needs trust. So when it comes to Social Security, so a lot of times people hear the word SSI and they think of Social Security. So SSI and Medicaid is a whole different animal than Social Security, Rsdi, also called Social Security Disability. So as workers, as parents, we're paying into Social Security. In exchange for one day when we retire, we're going to have retirement benefits through the Social Security Administration, or one day, if we ever become disabled, then we'll have Social Security disability benefits if the worker is fully insured. So basically what I'm saying is you're paying into the Social Security system. So as if you're a homemaker, if you're a caregiver and you don't have a work record yourself, you yourself are not necessarily covered for Social Security disability if you don't have enough work credits under your record. You'll still be eligible for Social Security retirement, possibly under your spouse's record, but Social Security disability is based off of your own work record. So when it comes to Social Security, there's something, and it was mentioned in the chat box a little while ago, about RSDI, Retirement Survivors Disability. So we talked about Social Security Disability, also called SSDI, and then we've got this RSDI, Retirement Survivors Disability Benefit. So as it relates to our kids, when it comes to the Social Security Administration, there is something called Childhood Disability Benefits, and this is where they can be covered under your record as a disabled adult child. They used to call them DAC, D-A-C, Disabled Adult Child. And basically, if your child's disability began prior to age 22, okay, it doesn't mean you had to apply prior to age 22. The disability had to begin prior to age 22 in the eyes of the Social Security Administration. Then it is possible for your child to qualify for childhood disability benefits under a parent's record. It is also possible under a step-parent's record. If grandparents have guardianship, it could be under a grandparent's record, but typically it's a parent. Once they are considered for childhood disability benefits, what this means is that when one parent either retires or becomes disabled themselves, your disabled adult child will be eligible for 50% of that parent's benefit. So in that example, that the parent has retired and they're getting $3,000 a month in Social Security benefits, that child that is eligible for childhood disability benefits would be eligible for $1,500. At that point, they would switch over to Rsdi. They would still maintain their Medicaid eligibility. They'd still keep Medicaid, but they wouldn't be getting Rsdi plus Social Security. In that example, that big example of your Social Security benefit is $3,000 and the child's is $1,500. Now, if your Social Security benefit is much less, then the amount does have to be over, I think it's over $806, that 50% amount, for them to switch over to the Rsdi. So some families, their kids are getting a portion of SSI. They're also getting a portion of Rsdi. And then sometimes they're also getting, I've seen this a couple of times in the last year, they're also getting SSDI themselves because they have their own work record as well. Okay, so let's see. Someone says, I'm just checking the chat box here. What is Rsdi? Again, Rsdi is the Retirement Survivors Disability Insurance, and TRS is the Texas Retirement System. A lot of teachers, not all teachers in the state of Texas, there's some districts in Austin and some other places where they actually do pay into the Social Security system, but most districts, they're not paying into the Social Security system, TRS. Then we have another good question here. Does a 529 account count against them? And so that is a loaded question, and that is one that we get all the time. So what she's talking about here, the 529C for college. A lot of us have 529Cs for our kids for college, but we're not sure if our kids are going to go to college or not. So there's a difference between a 529C and a 529A. So an ABLE account is actually under the same tax code, 529, but it's under A. So the deal with a 529C, the account owner is usually the parent or the grandparent. The beneficiary is your loved one. You reserve the right to change the beneficiary at any point. If funds from a 529 are going directly to a university, it shouldn't be counted against them. And of course, a 529 that is in your name as the account owner isn't going to be counted against them. So for families that have a 529C for their child that is maybe most likely not going to, higher education, community college, or a university, you can convert. They passed this law, I guess it was 2014, maybe 2018. Anyway, they passed a new law that you could convert a 529C to a 529A, but you still have to follow the rules for the 529A, which is you can only put $15,000 a year into an ABLE account. So if you have a 529C with $100,000 in it, it is basically only the $15,000 a year that can go to the ABLE account. The Ugma account, we have another question on an Ugma account. We don't see very many Ugma accounts anymore. They did exist. They were very popular in the 80s and the 90s. But the problem with the Ugma account, there is a real problem with it, is that Ugma account becomes the property. Once they turn 18 or 21, it becomes their, I believe it's 18, becomes their property. So then they have these assets in their name, and it definitely would be counted against them for that purpose. Okay. I think I have another question. I'm not sure I've answered it. There was a question about somebody under 18 years old. please just rephrase that question. I'm not sure I understand the question. As it relates to how do we fund a special needs trust, so there's different types of trust out there. There's a first party special needs trust. This is an example of your child's money. Maybe there was a lawsuit, there was a settlement, maybe they get a refund from a scholarship. That would be an example of the child's money. That's going to be a first party special needs trust, and there is a Medicaid payback on a first party special needs trust, okay? Another example of first party money is child support. In the state of Texas, a lot of families will continue to receive child support post age 18. This can be problematic. They're still working out details, in the judicial system. Not everybody in the judicial system understands preserving eligibility for SSI and Medicaid. But bottom line is, as it stands right now, if you're going to get child support post age 18 of your child, it's going to be imputed as income to them. Basically, 2/3 of the amount is going to be counted as income, and it may cause them to either get reduced SSI or no SSI whatsoever. So in order to fix this, you're going to need to have that redirected to a first party special needs trust, okay? The third party special needs trust is how we leave assets appropriately to our children. So that way, when we die, our life insurance proceeds, maybe assets of other accounts, existing accounts that are left over after we've retired and we're gone, this is how we leave them properly to our kids as a third-party special needs trust. And usually how this looks, it might say, so let's say your child's name is Johnny Smith. In this example, it would be the beneficiary would be set up not to Johnny Smith, but it would be to the third-party special needs trust for the benefit of Johnny Smith, or to the supplemental needs trust for the benefit of Johnny Smith. So when we talk about that, one of the things that we talk about quite a bit is making sure that you have your beneficiary designations set up properly. If you've visited us before and kind of attended some of our webinars, we really talk about this probably almost every webinar. Because a lot of families, what they do when it comes to life insurance or anything that you can have a beneficiary in, like such as a 401k or anything like that, they set their spouse as the beneficiary, and then they have a contingent beneficiary that basically says that if I die and my spouse is already dead and gone, then I'm going to leave all of the assets to my children divided equally. And then they name the children outright. This is problematic because it's problematic for two reasons. Number one, for your kids that don't have disabilities, if they're a minor and you leave them outright the money, it's going to sit in trust until they turn 18. And then when they turn 18, they're going to get all of the money. So that's a problem because most 18-year-olds can't handle large sums of money. They don't do well with it. It's gone within 6 months or shorter. So that's a problem. But as it relates to your special needs child, if you leave the money outright to them, they're going to disqualify for SSI and Medicaid. And basically the only option that a person has at that point is either to be disqualified or to hire an attorney and to get a court order for the judge to redirect that money to a first party special needs trust because it was left directly to that individual, to your loved one with a disability. It would have to go to a first party special needs trust, not a third party special needs trust. So the best thing to do is to have your special needs trust either set up now, or there is a way that you can have a will with a testamentary special needs trust that will basically, the special needs trust will form upon your death. So there's a couple of different ways to go about doing this. But what you need to know as far as these beneficiary designations, you need to have these meaningful conversations with your parents as well. Parents, grandparents, any family members that might leave any amounts of money to your special needs child, you need to have these beneficiary conversations as well. And if that is the case, we do have loved ones, grandma and grandpa, or somebody that's intending to leave money to your loved one, then in fact, you do need a special needs trust, not a testamentary special needs trust, because the trust will have to be set up already because it would be based off of their death, not yours. So the testamentary language is not going to work. So an attorney, we have, an attorney is going to talk to you about all of those options, what might be best for your unique situation. Every family is a little bit different. We have a lot of webinars regarding first party and third party special needs trust on our YouTube channel. You can check those out. And we're happy to make a referral if you're needing to work with somebody. We have another question about oh, okay. This is a great question, and I've got it clarified. Thank you for clarifying this for me. When we were talking about childhood disability benefits, we were talking about being eligible for 50% of the parents' either disability benefit or their retirement benefit. So the parent has to be on disability or has to be, drawing Social Security, retirement benefits. So the question is, to get the 50% of his, for one of the parents, does the age matter? And so that is a great question. And the answer is, so if a parent retires or becomes disabled and they have minor children, all of the minor children with or without disabilities are covered under that. Now, in that example, you have 3 kids and it's 50%. We use the example of $3,000, and the eligibility amount is $1,500. That $1,500 would be divided by 3, and basically each kid would get $500. Is how that would work. Each kid would not get $1,500. So that is a great question. So if the kids are minors, whether you retire or you're on disability, the kids are covered. The kids that do not have a disability, when they turn 18, they won't be covered anymore. And you can apply for the child that turns 18 that has disabilities to continue that coverage to be considered a disabled adult child under the parent's record. So there is kind of that magic line in the sand of age 18 where you are going to have to contact the Social Security office at that point if they were already getting benefits as minor, when you still have one child that still has a disability and will need to be covered as for childhood disability benefits indefinitely. So another question that we have is, can an Ugma account be moved to a third-party trust? So yes and no. The answer is you can take a distribution, you can take the money out of the Ugma account, but if you're not using it for higher education, you're going to be taxed, and whatever penalties go along with that. So there's no such thing as a beautiful transfer or anything like that where there wouldn't be, any ramifications. You would have to take it out, take the hit, take the penalties, then you could put it in a third-party trust. I actually had this question come up this week from a caregiver of an adult with a disability that used to work. He can no longer work, but he actually had he had quite a bit of money in a 401k when he used to work, and she wanted to know if we could move the 401k to a special needs trust, and the answer is basically the same. You can't just change the name on a 401k owner, okay? So the answer is basically the same, but the problem is there's penalties. If you're taking money out of that type of account, you're going to have penalties for taking money out prior to 59.5. Then you're going to pay taxes. And then, so it's not pretty. It can be done, but it's not a pretty way to go about doing it. Then we have a question that says, does Medicaid Payback apply only to Medicaid benefits received after age 55? And no, we understand that answer is not that the answer is no to that. So if they're receiving Medicaid benefits, there's a calculation, and it is convoluted. So if you Google this, you go to the Social Security Administration and look at the rules of the Medicaid Payback. It is convoluted. But basically, one of the things I need to tell you on that ABLE account is that different from that 529, The ABLE account, the individual with disability is the account owner, okay? So basically, if something happens to your loved one and there are remaining assets in the ABLE account, those assets would be the estate. They would go to the estate of your loved one that passed away. Is how that would work. And we'll go deeper and wider on that Medicaid payback. But basically, they come in and they take what they are supposed to take, and they have all their convoluted calculations that they do. And again, any remaining account balance is going to go to the estate of that individual. So then we have another question that says, can you explain the first party versus the third party special needs trust that you mentioned? Again, on the first party special needs trust, this is your child's money. This might be a lawsuit where they were left money. This could be an example where grandma and grandpa left money to Johnny Smith instead of to the special needs trust for Johnny Smith. This could be a scholarship, a reimbursement, a refund on the scholarship. That's all first party money. And again, first party trust, this is where child support after age 18, if you're getting it, needs to go to a first party special needs trust. The third part, some people never will ever need a first party special needs trust. Other people do. Other people need both, right? The third party special needs trust is, specifically, this is how we want to leave money and assets to our loved ones with special needs that have future care needs, because there is no Medicaid payback on a third party special needs trust. So this is going to be the most common. This is going to be what everybody needs. And some people will need a first party trust and others will not. It just depends on, again, if you've got child support or if you've got any kind of settlement or anything else that is the child's money. Okay, we've talked about a lot. We've kind of gone deep and wide and kind of strayed away a little bit from the waivers. And with all of these webinars, we really try to put out a lot of information as it relates to things that could affect the status, could affect whatever the conversation is that we're having. What we really recommend is that the things that we've got on this page here, we want these things to be on your radar. I know that we have a lot of people that attend, and then they attend our events regularly, and we're glad you come back. We're glad you hear it again, and sometimes we probably sound repetitive, but you know what? This is a lot, and if you feel like it's a lot, you're not alone. This is why we put this out there, because like I said, I do this for a living. I've got 2 kids that have special needs, and I felt angry. I felt so angry of how hard everything was, how to navigate through all of these things. But we can help you. We want to help you. We can help you develop a comprehensive special needs care plan. If you're wondering, what does this look like? How much do we need to set aside? Do we have enough? When can we retire? Can we retire? Are we going to run out of money? Those future care cost estimates of what it's going to look like if you have a child that's going to need care forever, as opposed to they're going to get out and they're going to go to college and what have you. We can help you put all of those things together. Another thing, I mentioned earlier that we are nationally certified as a Social Security advisor. We truly have a specialized software that is specifically designed for families that have kids with disabilities, as well as if they have a spouse that has been a caregiver and might be drawing off of that other parent's record. So this software allows us to do a calculation, and it really helps the family understand how and when to pull the trigger. What does this look like? How do we maximize the benefits for all parties involved, for the household, for Social Security? And it can get very convoluted. Somebody mentioned TRS. Our software takes into consideration any offset for TRS or government working and things like that, so we can help you with that as well. But all of these things, all of these little bullet points, we talked about a lot of these anyway. But what I would say is go to our YouTube channel, follow our YouTube channel, and we have recordings on all of these. We're putting out webinars on a weekly basis, usually 2 to 3 times a week. We have webinars, so we hope that you'll come back and join us again. But at your leisure, you can kind of sift through the ones on our YouTube channel and see which ones might be a good one. One thing that we didn't talk about, and again, there is definitely multiple guardianship webinars out there. That's a big one that comes up all the time, of guardianship. Do I need guardianship? Is there a partial guardianship? In Texas, we have the supported decision-making agreement, power of attorney, healthcare power of attorney, et cetera. The guardianship, you can start this process 6 months in advance. So that's one thing that you should know. 6 months prior to your child turning 18, you can start that guardianship process. And a general rule of thumb, most of the attorneys that we work with, the general rule of thumb is if your child's IQ is 70 or below, they doubt the capacity for them to understand what they are signing, right? So having them sign a supported decision-making agreement, a power of attorney, or a healthcare power of attorney is questionable. Most attorneys I've seen won't sign off on that, okay? So that's a discussion to have with the attorney. A guardianship, you know, a lot of families may need guardianship at first, or partial guardianship, because their child isn't fully mature. They're not there yet, but they're still hopeful and optimistic that they're going to get there. You know, you can have guardianship and end up with your loved one getting their rights back later as they mature. There's all kinds of things out there, but these attorneys are really going to help you. They're going to sit down. They're going to really talk to you and understand, you know, what the challenges are, what the needs are, and they're going to guide you in the right direction for that. A lot of these hearings for guardianship, it is a whole process, and like I said, that those webinars will kind of talk to you about it. But a lot of these hearings due to COVID have moved to Zoom, so that is kind of a change in some of the process. How and when they're going to get back to face-to-face in courts, I'm not really sure. So this right here is my team. I always like to just take a moment to just share that at Consolidated Planning Group, we work on a collaborative team. I work with some awesome professionals. So whether you work with me or any one of us on the team, we're here to help. We're all nuanced and special needs and can definitely help you in your journey. And so for our contact information, we've got that here. I think we mentioned our Facebook and YouTube. There's some links for that on there. And if you are wanting to talk a little bit more about your unique situation, or you need some help, we hear all the time, I don't know where to get started, or I've started and then I stopped and I don't know where to pick up. I just need help. I need you to help me get organized. We're happy to help. So reach out to us. We're happy to chat with you. It's not about looking back, about what you haven't done. It's about looking forward. You guys are here today. We're glad you're here. And we hope to, really make your journey a little bit easier along the way. So let me see if I just have any other questions. Okay, that's it. Thank you. Thank you, everyone. Thank you for being here today. It's been my pleasure, and I hope to be back with you again soon. Take care.